Lawsome by ConsultWebs. Breakthrough insights to build a thriving law firm with your host, Tanner Jones.
Hello, Lawsome listeners. Today on the show, very excited to be talking with Todd Franklin. He's a longtime friend, but he's also the partner and co-founder at Massive, made up of medical and subrogation specialists. Todd's expertise lies in assisting law firms in fostering a culture for profitability, enabling them to thrive in a competitive legal environment. As a renowned thought leader, he employs disciplined and well-documented systems that consistently yield measurable results for his clients. With an exceptional ability to identify and implement effective solutions within the legal industry, Todd has established a reputation as an expert in creating sustainable strategies for law firms. Today's topic, it's around managing time between settlement and disbursement to maximize a law firm's profit. Todd's going to share his insights and his experiences as a strategist within the legal profession. So welcome, Todd. Honored to have you on the show finally.
Thanks, Tanner. It's really good to be here with you as well.
Wonderful. Well, let's just jump right in. So
Sure.
Let's start with law firm management. It's important. We talk about lagging indicators, leading indicators, and all things indicators in an effort to really determine the financial health or even the growth potential of a law firm. But specifically around the waiting time between settlement and disbursement, that is certainly a metric that one could track. It would be considered probably more of a lagging indicator. So in your opinion, how do these indicators begin to give insights to law firms around their own financial health and performance?
Thanks. It's great to be here, Tanner. It's good chatting with you, and I look forward to answering some of these questions and giving folks an opportunity to listen in and learn a little bit about some of the things that we're doing over at Massive. Obviously, indicators teach you about your business. It gives you an opportunity to maybe ask questions that you haven't been able to ask before as you find new information. And so for me, I think that if you're going to start tracking indicators, some of the more important ones that you'll find are time on desk, right? And the initial one you had mentioned, which was, what is it? It's time from settlement to disbursement, right? Mm-hmm. And so that time on desk costs somebody dollars, right? It either costs the plaintiff time, it costs you time, meaning the attorney. And then you've also got other indicators that I think are important as well, too, which help you value your workload. And there's a lot that goes on, not just with the work itself, right? You've got a lot of things that affect culture and how work is actually accomplished. And so these indicators are true snapshots of what is happening with your business at any given time. And so as the more you learn, the more questions that you can ask, the more questions we can ask, the more we can learn. And then it just allows us to build off of a sense of culture, leading towards profitability. And it's just a really amazing thing what indicators can provide, whether they be lagging or leading indicators. It's important that you really have a sense of those prior to getting started.
Profitability is obviously a very important topic. So let's start there. What are you seeing in terms of effective benchmarks when it comes to assessing a law firm's profitability?
It's interesting. You can bring it into culture, right? So hiring tactics, right? So benchmarks are, having the right person in the right seat. When you look at the type of work that's done, it does take a specific set of skills. And so you can start as early as when you're hiring somebody. So a benchmark is, what is the talent, what is the skill that's necessary to do subrogation? Is that the same exact skill necessary to work directly with the plaintiff? And if that is different and it's a different makeup, then that has already given you an initial benchmark of trying to fill your staff with folks that are able to do and have the makeup of doing the work that's necessary to be done at different phases. So one is for sure absolutely the right person in the right seat. And then obviously time on desk. Again, going back to that, a benchmark is fairly simple to establish there. But the hope is that you can, by working both of these angles, you're able to attack not only the aspect of culture within your office, but also profitability by, hiring folks to the specific skills that you're requiring. I think a lot of times you'll find that without necessary benchmarks, you have maybe folks not always rowing in the same direction, not having the right person in the right seat, which will become an indicator at that point, because you'll see less opportunity, less business going in the manner that you may have thought you had designed it.
Lawyers, it's time you master the online arena. With ConsultWebs, dive into digital marketing without the guesswork. Our free law firm growth blueprint is tailored for legal professionals, offering precise, impactful strategies. Upgrade your online presence and outshine your competition. Are you ready for a digital revolution? Click on the link in the description or visit consultwebs.com for more information. Be the standout firm everyone notices. Yeah, I mean, it's often said that lawyers are not taught how to run a business in law school. And I'm curious to hear, just from your own personal experience, how top of mind are some of these indicators just from, any average law firm? Is this something that you're seeing being measured consistently from firm to firm?
Not consistently. It's different from firm to firm. Some firms, another benchmark really is recognizing and understanding the time of how long it takes to actually complete subrogation, right? It's not, you call on a Monday and it's done on a Tuesday. Mm-hmm. And if your timing isn't set properly, and so that's kind of what I see a lot of times is folks may think that they have the timing down, but then when you start to look at the timing and start to dissect the effect that it causes, then what you end up with is asking more questions and how can we improve this? But what you found is an area that you can. So what we see a lot of is law firms will call us with a case that's already settled and they're not exactly sure who they need to contact, or they have contacted already and they've got a really big lien that maybe exceeds settlement and things along those lines. And so, for me, my response is I don't like to harp on the fact that, you should have started earlier. This is a learning opportunity. And so if that side is interested in learning more about how this can become better and more profitable and build positive into culture, those are the kinds of things that we can start talking about. And then you just naturally start to build, better efficiencies.
So the world of medical liens for personal injury law firms, I mean, this is clearly, actually, I think it may help our audience start with describing a medical lien. What is a medical lien in a typical personal injury law firm? Like, what are they experiencing there? And what I'd like to lead to specifically is, the whole concept of getting somewhere faster as a business, tightening up processes, creates more efficiency, creates more profitability. So I'd like to lead in ultimately to what you're seeing with respect to early resolution, but let's start at the top.
So subrogation is basically the right to be reimbursed for some of what was paid for medical bills. And the example is if you're injured at no fault of your own and you hire an attorney, because you're seeking a third-party pot of money, that triggers a subrogative right for those who paid for your medical bills. Could be Blue Cross, could be Medicare, could be Medicaid. Because you sought and won a third-party pot of money, that triggers that right, allows them being the subrogating agent, Medicare, Medicaid, to be reimbursed for a piece of what they paid for your medical bills only related to the accident that you're seeking that third-party pot of money for. Mm-hmm. And so that is a quote-unquote lien, if you will, and they have that right. So lawyers, law firms have to contact them, provide them notice that a settlement occurred, and then the negotiation happens. And that is really what a lien is. They don't necessarily file the lien. Medicare is a statutory lien, and there are other statutory liens that are out there that could be attached to the case. But it's also recognizing what that lien looks like and what's the underlying language that's driving that. And so those are important things to get set up that lead to benchmarks as well, and learning more and more about how to set it up properly so that you can actually, have a great exit strategy.
That's good. And appreciate the explanation for listeners. And obviously personal injury lawyers listening, they live this. But I'm curious to hear from your experiences, even any kind of personal insights you have on the whole concept of early lien resolution and how that ultimately impacts a financial outcome for a law firm. What are your stories there?
So client satisfaction, financial stability, it all goes hand in hand. Starting early, law firms, and I've said this before, law firms spend a lot of money to get cases in the door, but don't have a really foolproof, thought-out plan in every situation for the exit strategy. And it leads to extended disbursement time. It leads to not great results with regard to ending up with a positive goodwill, right? You spend that much money to get a client in. You want to protect that because when they leave, you want them to be able to have that experience. And so, to me, client satisfaction, financial stability, all of that really kind of goes hand in hand. And, what I see is that when folks start early, understand if you settle a case pre-suit, you should be prepared to close the file out, right? And so whether you start earlier or later makes a very big difference on when you'll be done. And so, we like to talk with law firms about starting early. Doesn't mean that you need to monitor it every day, but opening up lines of communication, doing things to set it up for settlement will allow you to move the process quicker after settlement. And that to me is a really big deal. And then it'll give you an opportunity to audit liens prior to events like settlement conferences or in pre-suit if you're writing a demand. If you get an offer back, it's nice to know what your net medicals are, right? And you'll have an opportunity to be able to go through and see where your medicals really sit as far as from Medicare, whoever it might be that you've contacted to get a conditional payment history on or a payment history on.
Mm-hmm.
And so being able to start that process early, because there's always more that goes into it, right? There's always, this and that, or there's a short-term or a long-term disability plan that needs to be contacted, or it's ERISA, which becomes more complicated. And so all those factors lead to starting early, which will ultimately lead to better financial stability because you'll be able to close the cases faster, have a happier customer, and be able to, really borrow less at the end of the day. If it takes you 120 days or 90 days to get the money out, and you can do it in 60 days, there's less cost there.
That's it, more money in your pocket and clearly serving the client well. I mean, you hit on the importance of client satisfaction, and clearly that's a big part in all of this, and the quicker you can get things resolved, the better. But there's also the other side of this, which would be balancing a law firm's operational costs. So from your take, how do you maintain a balance between serving the client satisfaction side, along with consistent financial stability?
So one of the things I talk with law firms about is valuing your work, right? And so what work that I do is tied to revenue generation, right? What's profitable work that I do and what's not profitable work. And so once you get that list of both sides of that coin, you can then start to make decisions on, okay, where can we put our focus? And then from there, you can start to build into your culture, right? Then you can get the right person in the right seat, or you can decide that this is work that costs us too much money in goodwill, opportunity, and maybe bring in a partner to be able to help us with this so that we can move forward and not have to spend our time on non-revenue generating work, which is really just a cost to the firm and holds the firm back. And so I talk to law firms about evaluating the work that they have, what makes you money, what doesn't make you money, and who can help you decide, to work on profitable stuff, who can be there to do the work that you might have to do, but isn't profitable for you to do it, and can still be done. And so to me, that's an important thing to talk to law firms about, value of their work.
I love that concept. And it's true. I mean, we all get lost in our day to day, but I think it's a good grounding principle to consider.
It's a lot to think about. Like you said, it's a good thought, but there's also a process to deciding that you're going to work with an organization like Massive. And it's the excitement for me comes with asking questions, learning about whether or not it's a fit. And so our opportunities are to bring some of these up to the law firm, and whether or not we begin to work together, really it's just asking different questions. And I think that's exciting in and of itself.
And you've touched on this some, but I mean, while we're on the whole concept of client relationships and maintaining that essentially loyalty in the marketplace, do you have any personal experiences or stories that you would share that you've seen how the timeline between disbursement and settlement have ultimately impacted the relationship? Yeah,
one of my favorite things is when a law firm, starts with us and they begin to track more so time on desk and recognizing that the window has shrunk, recognizing that that we probably achieve better results as far as reductions are concerned than what they might do, because they don't always have the same expert person working on it. You may have a high-level paralegal who has been doing it for years and years and years, but that doesn't mean that makes the most sense. It doesn't mean that it can't get done at that level or higher at no cost to the firm. So for me is when people start to recognize that there's opportunity out there, and that the law firm isn't on an island, and that the law firms are already outsourcing work, right? They outsource expert work. They outsource court reporting, right? They outsource SEO and things along those lines. And so this is work that's high-level work. It's expert work. And we like to build off of that by asking those questions and really jumping in to see, how can we help? But, I think I got a little bit away from your question, but I think I touched on it enough.
Yeah, and I don't want to belabor the topic, but I think that's really the big piece here, is that it's what you don't know, and that's often the concept within a law firm, and essentially working what feels like an island sometimes, and there are so many experts tied to the whole the wheel of managing a law firm, and I think it's important to be able to address it. What other thoughts or closing feedback would you share with our listeners around these topics?
Transparency is key. I think that's an important feature. A lot of times I find law firms aren't able to be as transparent as they might want to be with their plaintiff when they call, because they might not have an answer. And so those types of things can help improve. And that most of what we do is driven by, making sure that we, shrink that window between settlement and disbursement, ask the right questions, and help law firms become more profitable and hopefully build a better culture for profitability, in that recognizing that there's other opportunities out there and it doesn't have to be you against the world.
I love that. It's a good closing thought. I mean, that's really a big concept to Lawsome and what we want to do for the legal community. And obviously profitability just continues to give our law firms across the country the ability to better serve clients over time. So very thankful for you being willing to share some of these nuggets with our audience. For those who are interested in maybe asking some follow-up questions with you, what's the best way they can reach you, Todd?
Sure. Anybody can reach me anytime at 248-213-8700. That's my direct dial, but you can also get me at todd@gomassive.com, which is my email address. I'm always available, and we look forward to hearing and answering any questions or beginning a relationship with anybody as far as asking questions.
Todd, thank you very much.
Hey, it's my pleasure, Tanner. It's been great talking to you, too.
Lawsome by ConsultWebs with Tanner Jones. For show notes, links, and info, go to consultwebs.com/podcast. Be sure to subscribe and leave us a review. Watch for the next Lawsome episode to discover more breakthrough insights to build a thriving law firm.